Calling our hearing back to order. Good morning. Thanks everyone for being here this Monday morning. I'm Jay Griffin, Chair of the Hawaii Public Utilities Commission, and with me virtually are Commissioner Jennifer Potter and Commissioner Leo Suntian. We also have our commission staff here present in the virtual hearing room in the WebEx. As we've noted throughout this hearing, this is an evidentiary hearing for Public Utilities Commission docket number 2017-0122, which involves the Commission's review of Hawaii Electric Light's application for approval of a power purchase agreement with Hu Honua filed on May 9th, 2017. Just to run through our housekeeping again, Mr. Parsons will be hosting the WebEx today in the hearing as well, be the point person for any technical issues that may arise. If you have problems, please consult the document that was sent to you, Procedures for Addressing Technical Difficulties at Hearing. We've been through the starting time. Thank you all again for being here on time. We'll be taking breaks in the proceeding at the discretion of the presiding officer as well, and for lunch break as well. It's noted in our pre-hearing conference order that provisions set forth in that order shall govern the hearing and post-hearing schedule. Commission's recording the hearing and is making publicly available on YouTube. This is critical for those listening via the live stream as well as those who listen to the recording to be able to hear clearly what each hearing participant is saying. Please speak slowly and clearly, and please respond to questions verbally so that the recording can capture your response. We reiterate our strong preference to not close any portion of the hearing from the public, which will require our suspending the live stream on YouTube. And again, opportunity for redirect examination and recross examination shall be requested orally during the hearing and is subject to the presiding officer's discretion. So we're up to our fifth phase examination of Tahiri Power's witness. So will Steve Pace please stand and identify himself?
Here, Commissioner.
Thank you, Mr. Pace. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, thank you. We'll begin with examination, cross-examination by Hawaii Electric Light.
Hi, good morning, Mr. Pace. One of the critiques that you've raised regarding the Hu Honua project is related to the minimum dispatch, correct? And that starts on page 3 of your direct testimony?
Correct.
Okay. And Tahiri's position is that's not in the best interest of Hawaii Electric's customers?
We don't think so.
Okay.
Particularly if it leads to curtailment of other as available or any renewables.
Okay. On page 7, line 14 of your testimony, you request that if the Hu Honua ANR PPA is approved, that Hawaii Electric Light be directed not to curtail Tahiri, correct?
Let me move to that. One moment. I'm sorry, which line again?
Page 7, line 14. 14 through 15. Okay.
And the question?
In making this request, is it Tahiri's position that Tahiri should not be curtailed even if there's more economical generation available?
That's our position, yes.
Okay. Is your testimony that this request by Tahiri is also in the best interest of the customers?
I guess it depends on the generation that is less economical than dispatching of Tahiri. Is it fossil fuel fired generation? Then we don't think that's going to be in the ratepayers' best interest.
Tahiri's pricing is based on avoided energy costs, correct?
Correct.
And that's tied in part to fossil fuel costs?
Correct.
And I won't ask you if you have a crystal ball because we've gone down that road a number of times in this hearing. You would agree that fossil fuel costs do go up and down and are at the mercy of many factors, including such things as our ongoing international conflict, wouldn't you?
Correct.
Okay. And Tahiri's project is not a firm generating project, is that correct?
As available.
And the PPA between Tahiri and Hawaii Electric Light sets forth the terms of the purchase of energy by helco from Tahiri?
Yes.
And to your knowledge, there's been no request from helco to modify the existing terms of the PPA?
No, there hasn't been.
Okay. And Tahiri would have to agree to any such modification, wouldn't it?
Correct.
And Tahiri's position here today is not that the curtailment of Tahiri is in violation of any of the terms of the PPA between Tahiri and Hawaii Electric Light, correct?
Can you repeat that one more time, please?
I said Tahiri's position today is not that the curtailment of the Tahiri project is in violation of any of the terms of the Tahiri PPA. Is that correct?
Mr. Chair, I would object. Is Mr. Stewart calling for a legal conclusion from Mr. Pace?
I'm asking about the position of Tahiri. Mr. Pace is the only witness that Tahiri's put forward. And so I'm trying to get a sense of whether or not he's saying that they curtail. One of the things that's raised in his testimony is that Tahiri is against the curtailment of the Tahiri project. I'm trying to get a sense of whether he's saying that that would be in violation of the contract that Tahiri signed with Hawaii Electric Light.
Can you expand on what you mean by curtailment, please?
We'll allow the question. Please continue.
Yeah, I guess I have I have a question concerning what you mean by curtailment.
Okay. Earlier, we looked at your testimony where you said that Tahiri requested that Hawaii Electric Light be directed not to curtail the Tahiri project in the event of an approval. And I'm trying to understand whether you're saying curtailment of the Tahiri project would be in violation of Tahiri's power purchase agreement. And if you don't know, that's fine. I'm just asking the question.
Well, I mean, it's going to be contingent on the situation. So if our facility or actually any, renewable generator, I mean, again, it's depending on their contract, but if we get curtailed so that helco can purchase from Hu Honua, we wouldn't feel comfortable with that at all.
Thank you, sir. My question was not as far as comfort. My question was as to whether or not you are aware of that, whether that would be in violation of the PPA between Hawaii Electric Light and Tahiri. I understand it's not maybe preferable from Tahiri's perspective. I'm just trying to get a sense of whether or not you have an opinion on that issue. If not, that's fine. We can move on.
I really don't have an opinion. Again, it's going to depend on specifics of the curtailment.
Thank you, sir. Tahiri did not file a notice of appeal as to the Commission's prior 2017 approval of the Hu Honua A&R PPA, correct?
Correct. We were very limited in how we could participate.
Okay. I don't have any more questions. Thank you.
Thank you, Mr. Stewart. Next is a consumer advocate.
We have no questions for this witness. Thank you.
Thank you. Next is Hu Honua.
Thank you, Chair. Good morning, Mr. Pace.
Good morning, Mr. Yamamoto.
Is it your understanding that environmental costs are issues in this proceeding?
Yes.
I'd like to turn your attention to your response to Hu Honua TP-IR-29H.
Let me pull it up on my hard copy here.
Sure, take your time.
And what date was that filed?
This was October 21, 2021.
Okay, and then IR again.
This is HHB-TP-IR-29H. And we're sharing our screen as well, in case that's helpful.
Very good.
So the question asks, please explain what Tahiri means when referring to, quote, environmental costs. And your response in subpart H.
Mm-hmm.
You see that?
Correct.
And if you go 5 lines down, starting with the word additionally, it says, additionally, environmental costs include 1, potential water pollution and effects on ocean activities, including sea life and recreation and commercial activity. 2, the displacement of animals due to tree cutting and changes to their natural environment. 3, soil erosion and soil carbon capture due to deforestation. 4, waste disposal. 5, noise and light pollution. 6, non-GHG emissions. You see that?
Correct.
So for those additional environmental costs, is it your understanding that these are issues in this proceeding?
Yes.
I'd like to turn your attention to another IR response you provided. It's in HHB TP IR 34B. This was filed on October 21, 2021. And the question asks, please explain how Hawaiian hoary bats are relevant and or material to the statement of issues. You see that?
Yes.
And your response to subpart B states Hawaiian hoary bats may affect Hu Honua's cutting of trees and in turn may affect its fuel supply and ability to meet the terms of the amended PPA as noted in issue 4. You see that?
Yes, I do.
Do you have any evidence of the existence of Hawaiian hoary bats in Hu Honua's feedstock plantations?
I personally don't.
Have you observed any?
I personally have not.
Thank you. I'd like to turn your attention to your response to Tahiri's SOP at page 8. This was filed on December 21, 2021.
Page 8.
That's correct. And at the very top of the page, it states, the fact that Helco did not retain Ramble to do all of the analysis is inappropriate and raises many red flags in regards to the credibility and validity of the updated GHG analysis and the net GHG emissions calculated. For example, the analysis done by Ramble does not include estimated GHG emissions for sequestration, while ERM's analysis does. You see that?
Correct.
What did you mean by GHG emissions for sequestration?
Well, I guess the term sequestration, it can be pretty broad, correct?
Well, I'm asking what you meant by that phrase.
Again, we had referred to the Helco response to PUC Helco IR 20. So any reference to sequestration, we would need to look at that.
Okay. Do you know whether Ramble included in its analysis information regarding carbon sequestration?
Only to the extent that it would have been included in ERM's analysis.
Okay. Are you aware that Ramble covered the avoided emissions and ERM covered the project emissions for this project?
Correct.
And are you aware that Ramble then took ERM's project emissions and added it to its avoided emissions and calculated the net overall emissions reduction?
My understanding.
Thank you. I'd like to turn your attention to the same Tahiri SOP at page 8. A little further down, it states, moreover, the updated GHG analysis is flawed because it assumes that Hu Honua will only displace fossil fuel units, which is contrary to the position of Helco. Helco has made no commitments to retire any of the existing fossil fuel units on its system if Hu Honua comes online. Do you see that?
Yes, I do.
So why did you state that the updated GHG analysis is flawed because it assumes that Hu Honua will only displace fossil fuel units?
Well, we'll have to refer to, I believe it's T5, Helco's testimony on the bottom of page 13 of T5, where it notes that the GHG emissions are defined as the estimated avoided GHG emissions from fossil fuel and biodiesel fuel plants, minus estimated project GHG emissions as calculated by ERM. Now, we did not see anything in ERM's analysis that included curtailment of other renewables.
Did you see anything in Hawaiian Electric's testimony or analysis that indicated that they were assuming that only fossil fuel units would be displaced for their GHG calculations?
Well, that's a very good question. So we reverted back and we asked Helco in Tahiri Helco IR 33C, what was the greenhouse gas emissions analysis based on? And if you go to that IR and Helco's response, it was rather, I'll put it, cryptic concerning whether renewable generation would have been included or not.
So, okay. Did you see anything that affirmatively states that Hawaiian Electric assumed only fossil fuel generation in its analysis that would be displaced in its analysis?
That was the T5 testimony.
Does ERM's analysis state what fuels will be displaced by Helco?
No.
Does the Ramble report itself assume that only fossil will be displaced?
Does fossil also include the biofuel? I think per the testimony that it was both fossil and biofuels that would be displaced.
Are you aware that Helco considered the displacement of biofuels as zero, so it didn't count?
That's an interesting argument there, whether it's zero or not, but that's another discussion for, I guess, another day.
Okay.
Yes, I was aware of that.
Okay. But did you see anything within the Rambo report that indicated that only fossil will be displaced?
No, I didn't, that I know of.
Did you consider the cost of GHG emissions associated with burning fossil fuels in your review?
No, our focus was not on the greenhouse gas analysis per se.
Would you agree that the cost associated with GHG emissions with burning fossil fuels is a real cost and should be considered?
Yes, and I believe that's what this is about.
Mr. Chair, I'm going to object. Where is this relevant to Mr. Pace's testimony?
Yamamoto, can you further explain the basis?
Yeah, Mr. Pace talked about not only pricing, but also the GHG analyses in this proceeding. He called into question its veracity and reliability. And so I'm just asking questions related to GHG emissions and its related cost.
Okay, we'll let the witness did answer.
Thank you. Mr. Pace, I'd like to turn your attention to your response to HHB-TP-IR-29G. This was filed on October 21, 2021. And so the question asks, in Hu Honua testimony T4 and Hu Honua 402, project GHG analysis filed September 16, 2021, Hu Honua presents its analysis, which reveals that the Hu Honua project will remove more GHG emissions than it emits and will be carbon negative in year 2035 and beyond. Based upon the project GHG analysis, please explain whether Tahiri still believes that there is a, quote, unknown environmental cost. You see that?
Yes, I do.
Further down in your response, Tahiri stated, Tahiri objects to this IR to the extent that it is based on a false premise that Hu Honua 402 project GHG analysis is accurate. You see that?
Yes, I do.
So did you call into question the accuracy of the project GHG analysis?
We made a statement that we had concerns about of its accuracy, yes.
Okay, and has Tahiri prepared its own independent GHG analysis to assess the GHG of impacts associated with the Hu Honua project?
No,
Do you consider yourself an expert in the area of GHG accounting and GHG impacts?
no,
Do you think you're qualified to evaluate the accuracy of Hu Honua's GHG analysis?
the accuracy or no. The assumptions, yes, that's something I think we could look at.
Are you able to identify what specifically in ERM's GHG analysis is inaccurate with respect to the assumptions?
Mhm. Well, do you want to pull up the analysis?
Do you recall what specifically?
Not off the
were
top of my head,
assumptions?
no.
Okay, we'll move on. Mr. Pace, I'd like to bring your attention to HHB TPIR 29G. It's the same, I believe it's the same response to Hu Honua's IR dated October 21, 2021. And in it, it states that Tahiri still has concerns with the project GHG analysis. For example, it does not appear that, one, the results of the JBP report were included in the GHG calculation. Two, Table 8 includes the carbon loss from eucalyptus harvesting. Three, Table 9 includes the total emissions for biomass and ash transport. And four, the estimated emissions associated with equipment decommissioning was considered. Do you see that?
Mm-hmm. Yes, I do.
And so based on the testimony that you've heard during this hearing, has your answer changed, or do you still have concerns that Hu Honua's GHG analysis did not address those things?
Those questions, I believe you responded to, and so we had no more questions concerning that.
Okay, so you no longer have that concern. Is that right?
We no longer have questions concerning that.
Okay, thank you. Subject to check, are you aware that the JBP report is included in Hu Honua-402?
Can we review Hu Honua 4-2, please?
Sure. Share our screen. Okay, so this is an Excel spreadsheet that was filed together with
Great.
ERM's GHG analysis. And in Table 7, it's titled Construction and Commissioning.
Okay.
And so this page, would you agree that this page includes JBP's reports, figures regarding construction and commissioning? At the very top right
Without
of this.
careful analysis, I'll have to take your word for it.
Okay. You. Are you aware that Table 8 in the GHG analysis includes information regarding carbon loss and eucalyptus harvesting?
Very good.
So that's no longer a concern?
Again, we peripherally reviewed the greenhouse gas analysis. This was not something we are or we were neither able to secure the consultants, nor are we experts in greenhouse gas analysis. We only peripherally reviewed this, we asked our questions and moved on.
Okay, yet in your IR response, you responded that you had concerns about certain information that was missing from Hu Honua's GHG analysis, correct?
And I believe, as I noted, you answered those questions.
Okay, so my question is, do you still have those concerns that Hu Honua's analysis lacks that information?
Based on your answers, no, and the questions that we had asked. Now, as a whole, I can't answer that.
Okay, thank you. I'm going to move on. Mr. Pace, I'd like to draw your attention to HHB, your response to HHB TPIR 30F1 that was filed on October 21, 2021. And your statement there says, helco has too many generators on its system, which they have designated as must run. This is the status quo. By adding the Hu Honua facility with its 10 megawatt must run provision, helco will continue to perpetuate the status quo. You see that?
Yes.
Can you please explain your understanding of how Tahiri is dispatched by Hawaiian Electric?
Typically, it's dispatched at 100%.
Okay.
Now, what do you mean? Well, continue.
Yeah, so why do you believe that helco has too many generators on its system, which they have designated as must run?
I believe, didn't we refer to my answer?
What was your answer?
We referred to again, can you go back to the question again? Which question it was? It was G.
Sure, it's 30F1. So it asks, define what Tahiri means by status quo and provide the basis for Tahiri's assertion that the approval of the amended PPA will perpetuate the status quo. And you were referring there to Hawaiian Electric's must run.
Correct. So we happen to be looking at the generation that helco posts, Helco has posted on their website, and noting that when you add up all that generation and the minimum that they dispatch that generation, that this additional 10 megawatts without the capability of being cycled off would add too much must-run generation to the system.
Okay, and is your
Especially
concern
during periods, especially during periods of low loads.
Okay, sorry for interrupting you there. So then are you concerned that Hawaiian Electric may curtail Tahiri? Is that your real concern?
Correct.
And do you recall what the effective date of Tahiri's contract with Helco was?
Not off the top of my head, I believe. The PPA the PUC approval date, I'm sorry, or the commercial operation date.
The PPA effective date.
It was, I believe, sometime in 2004.
Your understanding that Tahiri has priority in curtailment over all later IPP contracts, meaning that Tahiri cannot be curtailed unless those later contracts have been curtailed first.
Those later as available contracts, yes.
Have you reviewed the base case and alternate case resource plans that form the basis of Hawaiian Electric's bill impact analysis?
Concerning Hu Honua?
Concerning the Hu Honua project, correct?
And which, okay, go ahead.
Mr. Chair, could you ask counsel to clarify which exhibit he's discussing? Because there were several reiterations of the bill impact. And so which exhibit is he referring to the client or the witness?
Sure.
Okay, yeah, please,
But-
either
So-
provide or if you can share the screen.
Just a moment. Try to share our screen, but I believe, Mr. Pace, it's Hawaiian Electric's bill impact analysis, helco-301, which shows Hawaiian Electric's dated resource plan.
And when was that filed?
It was filed on November 22, 2021.
So we're discussing the NG project?
No, this is the Hawaiian Electric Hu Honua bill impact analysis. Sorry, at the very top, you can see that it's labeled. Sorry, we'll share our screen. Helco-301.
Just to be clear, Mr. Yamamoto, this is the updated version of that exhibit, given the PUCIR, correct? I think
That's correct.
That's what the witness was asking.
That's correct. And yeah, I should clarify that this is Hawaiian Electric's response to PUCIR 17.
Very good.
And it was filed on November 22, 2021.
Mm-hmm.
And on the page labeled Helco-301 at the very top right, this table here refers to updated resource plans. I was just asking if you're familiar with the base case and the alternate case resource plans indicated in this table.
I know about them, yes.
Okay, and are you aware?
Intimately.
Are you generally aware that Hawaiian Electric forecasts a substantial amount of new renewable capacity over the next 30 years, including the RFP1 solar projects?
Yes.
Okay, and given that the projected capacity comes from IPP contracts, as I believe Helco testified to earlier, and the only signed contracts to date are with Waikoloa Solar and Halekuawehi Solar, wouldn't Tahiri's contract with an earlier effective date give you curtailment priority over new additions?
We have questions concerning that. We have not seen a curtailment queue involving those PPAs, so.
Okay. Thank you. I'd like to turn your attention to Tahiri's statement of position at page 3. And on page 3, at the top, starting at the top, it states, Tahiri was compelled to file its motion to intervene because it was concerned about being curtailed by the proposed Hu Honua project because of the must-run provision included in the PPA. According to the PPA, Hu Honua had a minimum dispatch of 10 megawatts. This operational inflexibility agreed to by Helco meant that the Hu Honua project had the potential to cause curtailment of Tahiri's project as well as other renewable energy generators, particularly since Helco refused to agree to retire its fossil fuel generation to accommodate Hu Honua. Do you see that?
Yes.
How much energy has been curtailed in recent years from the Pakini Nui project for reasons of oversupply or system constraint?
In recent years, so since Huna Geothermal has come back online, we have seen increasing amounts of curtailment. Prior to that, and subsequent to PGV being knocked offline, we did not see any curtailment really to speak of concerning excess as available energy.
Okay. Would you accept, subject to check, that according to the curtailment reports filed by Hawaiian Electric from 2019 through 2021, the Tahiri Pakini Nui wind farm had a cumulative 66 megawatt hours of energy curtailed due to oversupply?
Well, I think what the utility files and what, what our SCADA system tells us are two different things.
Okay. Would you also accept, subject to check, that those reports indicate a cumulative 43 megawatt hours for energy curtailed due to system constraint?
I'm sorry, the question again was?
Would you accept, subject to check, that there's a cumulative of 43 megawatt hours for energy curtailed due to system constraint?
Without seeing the numbers and subject to check, I'll believe you.
And how much energy did helco purchase from Tahiri Pakini Nui in those years, 2019 to 2021? Do you recall?
It would be over 300 gigawatt hours.
Okay. Would you accept, subject to check, that according to the annual financial reports filed by Hawaiian Electric with the PUC, it was 111,000 megawatt hours in 2019 and 118,000 megawatt hours in 2020?
That seems reasonable. Subject to check.
Okay. So if Tahiri sells over 110,000 megawatt hours per year to Hawaiian Electric and has had less than 110 megawatt hours curtailed for reasons of oversupply or system constraints in the last 3 years, then only about 0.1% of Tahiri's energy has been curtailed due to must-run generation, correct?
Over that time period, yes.
Okay, so isn't the basis for Tahiri's concern not renewables such as Hu Honua, but rather helco's policy regarding dispatch over sometimes prioritizing fossil generation over renewables?
I think that's been a concern, yes.
Thank you. Mr. Pace, are you aware that during the remaining term of Tahiri's PPA, even if Hu Honua was not on the system, current fossil resources will be operating at minimum load or greater?
Okay.
Is that a yes? Are you aware?
Yes, they have not committed to cycling off or retiring, let alone retiring their fossil fuel units on their system, whether Hu Honua comes online or not.
Okay. Are you aware that there are operational requirements that require a certain amount of capacity online at all times?
Yes.
Are you aware that most of that capacity currently comes from fossil units?
Yes.
Are you aware that Hu Honua has operational capabilities similar to Hawaiian Electric's fossil units?
Yes.
Are you aware that Hu Honua can displace fossil generation with renewable energy?
Yes.
And are you aware that Hu Honua is capable of replacing a fossil unit's minimum load with a minimum of renewable energy?
Can you repeat? You broke up a little.
Sure. Are you aware that Hu Honua is capable of replacing a fossil fuel unit's minimum load with the minimum load of Hu Honua's renewable energy?
It has similar generation capabilities, yes.
Do you have reason to believe Hawaiian Electric would curtail renewables to accommodate minimum load instead of turning off fossil units whose functions can be fulfilled by Hu Honua?
Do I have reason to believe? I have definite concerns.
Has helco confirmed curtailment of Tahiri in any of the responses to IRs in this proceeding?
It's my understanding, yes.
You have confirmed that Tahiri would be curtailed?
I don't, you know, recall it.
Sorry, Mr. Pace, you're breaking up.
I guess that's the
Can you
answer.
please
but
repeat the response?
I
Sorry, Chair, I did not get that response.
believe that has come up and they have confirmed. To my understanding, okay, so I subject to check, I believe, yes, they have confirmed that curtailment of renewables. Can you hear me okay now?
Sorry,
You're still
Mr.
breaking up.
It's come in and out. If you could please a little
Breaking
better now.
up.
Yeah, can you repeat the response, please?
Let me stop the video. Hold on. Okay, it is, I believe, yes, it has, to my understanding and subject to check. Can you hear me okay now? Or am I still breaking up?
No, I can hear you now. Thank you. Is it worthwhile asking the question because
Yeah.
I wasn't sure if you
Sorry
heard
about
the
that.
question.
Yeah, Mr. Please do, Mr. Yamamoto, just so that we all are clear that you got the response.
Okay, thanks, Chair. Has helco confirmed curtailment of Tahiri in any responses to IRs in this proceeding?
I don't know that.
Do you not recall?
I do not recall.
Thank you. Are you aware that PGV's amended PPA contains a 26 megawatt must-take provision?
I believe it's 21.
Okay. And did you intervene in that PGV proceeding because you had concerns about their must-run?
Yes, we did.
Has Tahiri analyzed the Hu Honua project's impact on price volatility?
We have looked at that, yes.
Okay. And what was your conclusion regarding Hu Honua's impact on oil price volatility?
Oil price volatility? I'm sorry?
Yes. Would you like me to repeat the question?
Okay, hold on. Now you're breaking up. I just turned my video off again. Go ahead.
Okay, all right. Thanks, Mr. Pace. Has Tahiri analyzed the Hu Honua project's impact on oil price volatility?
No, I'm sorry. Why would Hu Honua impact oil pricing?
Well, for example, with Hu Honua online, there would be less reliance on fossil fuel. Did you consider that or analyze that?
Are you referring to the pricing? Can you repeat the
Sorry,
question?
I'm not
one
getting
more time,
his
please?
response because it's breaking up.
Yeah, Mr. Pace, especially with your video off, we can't tell if you're breaking up or, yeah.
Hi. So I don't know, I'm on a wireless. I can try in an Ethernet cable if for some reason I'm getting interference over my wireless. I apologize for this. Can you hear me okay now or no?
It's okay at the moment.
Okay, may I re-ask the question?
Okay. Mr. Yamamoto, can you please?
Okay. Has Tahiri analyzed the Hu Honua's project's impact on fossil fuel price volatility?
So I would object, Chair, because this is beyond Mr. Pace's testimony.
Mr. Yamamoto, witnesses started to respond a couple times.
Yeah, and
So,
I didn't fully hear the response.
correct. So please, Mr. Pace, do you need the question repeated? To be fair, also, Mr. Yamamoto, you've stated the question in slightly different terms, I think 3 times now. I think the first time you talked about price volatility, the
How-
second you talked about oil price
If Hu Honua
volatility, the third time you talked about fossil fuel price volatility.
Okay, I will try to consolidate my question. Mr. Pace, has Tahiri analyzed the Hu Honua project's impact on fossil fuel oil price volatility? Say yes or no
I
question.
have a yes or no.
Yeah, whether you
No.
analyzed it or not. Thank you.
No.
Have you analyzed? Okay, thank you. Have you analyzed the export of funds for fossil fuel imports?
Again, I
No.
would renew my objection. This is beyond the scope of the testimony by the witness.
Simply asking whether he analyzed it or not, and it goes to what he analyzed with respect to this project and its impact on fossil fuel generation.
We'll allow the question. Please respond, Mr. Pace.
No.
No? Is that your answer?
No.
Okay, thank you. Have you analyzed fossil fuel supply reliability risk in connection with the Hu Honua project?
Again, I would object beyond the scope of his testimony.
Same response, Mr. Yamamoto.
Thank you. Go ahead, Mr. Pace.
No.
And did you analyze GHG emissions? I'm sorry, strike that. I think I already asked that question. I'll move on. With respect to, I'd like to draw your attention to your statement of position at page 16.
You mind pulling that up for all?
Yes, I'll share my screen. Thank you.
Page 16.
Yeah, Tahiri's statement of position filed December 21, 2021 at page 16. Okay, beginning with the first full paragraph, it states, alternatively, if the commission is inclined to approve the amended PPA, it should approve it with conditions. The first condition should be that helco does not curtail existing renewable generators such as Tahiri to take energy from Hu Honua. Do you see that?
Yes.
Were there any other conditions that you would like the PUC to take into account if it were to approve the Hu Honua PPA?
Other than what has been stated in our SOP, no.
I'd like to turn your attention to your testimony.
I'm sorry, Mr. Chair. I just wanted to note for the record that the document that council has shared lays out a second condition that Tahiri is requesting from the commission. Thank you.
Thank you. It's noted.
Mr. Pace, I'd like to draw your attention to your testimony filed on September 16, 2021 at page 5. At page 5.
Yes.
And the wording starts on line 20. You state, the fact that the cost of generation from the proposed amended PPA starting at 21.7 cents per kilowatt hour is significantly higher than the most recent posting for avoided energy cost pricing of 16.1 cents per kilowatt hour on peak does not make for a cost-effective proposition and will only lead to higher rates for helco's customers. Do you see that?
Yes.
Are you aware that Hawaiian Electric's avoided energy cost for March 2022 is 21 cents per kilowatt hour on peak?
That is their avoided cost. That is not what Tahiri gets paid.
Okay. Thank you. Do you agree that helco's avoided energy cost increases when the cost of oil goes up?
Yes.
Are you aware that Hu Honua's energy pricing is fixed or predetermined under the PPA?
Yes.
So given that helco's avoided energy cost increases when the cost of oil goes up, isn't it conceivable that the avoided energy cost could be higher than Hu Honua Energy's pricing?
Potentially.
Mr. Pace, I'd like to turn your attention back to your pre-hearing statement of position at page 12. And we're highlighting the relevant language that I'd like to draw your attention to. It states, recent adequacy of supply reports do not support the need for Hu Honua's capacity. Do you see that?
Yes.
So my question is, what aspect of the adequacy of supply reports is the basis for your statement?
Actually, I don't recall. I have to look up that.
Would it be fair to say
Look up
that the
the
adequacy?
Look up the details of that supply report.
Would it be fair to say that the adequacy of supply reports measure resource adequacy, which is the ability to place an amount of energy on the grid that is greater than the load?
Okay.
Are you aware that Hawaiian Electric's energy reserve margin has a 30% target?
Very good.
Are you aware? Yes or no?
Yes.
Are you aware that the most recent adequacy of supply report shows that 260 megawatts of there's 260 megawatts of capacity, of which 235 megawatts is currently fossil fuel units?
On the helco system, the helco generation,
Yes.
subject to check, that's approximately, yes, my understanding.
And if Hawaii's goal is to reduce fossil fuel generation with renewables, shouldn't Hawaiian Electric maintain an adequate supply of renewable capacity as it eliminates fossil capacity?
Yes. It would.
Thank you. I'd like to turn your attention to the same document, Tahiri's statement of position at page 5. highlight the relevant language. So it states the Hu Honua costs are significantly higher than that of the two 30-megawatt solar plus battery storage projects that were recently obtained during the phase one request for proposals. Specifically, the cost of the two RDG, I think you meant RDG PPAs projects for Hawaii Island, AES Waikoloa Solar, and Halik Huawehi Solar LLC are 8 cents per kilowatt hour and 9 cents per kilowatt hour respectively. Do you see that?
Yes.
So my questions are, can the two phase one projects generate 30 megawatts of continuous capacity and energy 24/7?
Their capacity factor came in at about 32%. So the answer to that would be no.
Okay. And if the phase one projects are dispatched to only 50% of their NEP or net energy potential, would you agree that their rate would be approximately double at 16 cents and 18 cents per kilowatt hour respectively?
Their effective, given their lump sum, yes, the effective rate to the ratepayer would essentially double.
Are you familiar with a study conducted by Hawaiian Electric in the IGP docket that stated comparing the 30% ERM target case to the no thermal candidate case, a firm generator is approximately equivalent to nearly 7 times the capacity of PV plus 6-hour battery storage on Oahu?
I'm not aware of that. I'm sorry.
Are you familiar with the study Dr. Jacobs performed that showed during low solar periods, additional storage would be required, increasing prices by over 5 times to go over 45 cents per kilowatt hour?
I haven't seen that study.
I'd like to draw your attention to the same document, Tahiri's statement of position at page 6. And we highlighted the language for you. It says, indeed, Hu Honua's proposed cost of generation is even higher than the most recent posting for on-peak avoided cost pricing of 16 cents per kilowatt hour, which also makes Tahiri a lower cost renewable alternative to Hu Honua. Do you see that?
Yes.
Can Tahiri provide firm dispatchable renewable energy to the grid upon demand 24/7?
No.
Are you aware that Hu Honua will grow native forests and plantations and harvest only from commercial plantations?
That's what Hu Honua is stating, yes.
That because of this project, there will be more native forests than at the beginning of the project?
That's what Hu Honua has stated, yes.
And are you aware that Hu Honua will be the first carbon negative energy project in the state of Hawaii?
It has the potential for that, yes.
And I'm going to ask this a little different way. Are you aware that Hu Honua will not be harvesting from any native forests?
Yes, I think that would be, that's my understanding.
Okay. And are you aware that Hu Honua will plant native trees?
That's my understanding.
And looks like I'm down to my last question. I'd like to draw your attention to Tahiri statement of position at page 15. Starts with the word therefore. We highlighted the language for you. It says, therefore, Tahiri would respectfully recommend that the commission deny helco's application for approval of its amended PPA with Hu Honua and instead recommend Hu Honua submit their project to the phase 3 RFP. Do you see that?
Yes.
Are you aware that the Stage 3 RFP makes Hu eligible for Stage 3 because it already has an existing contract with Helco?
So you broke up a tad there. Can you please repeat that?
Sure. Are you aware that the Stage 3 RFP makes Hu Honua ineligible for bidding into Stage 3 because it already has an existing contract with Hawaiian Electric?
My understanding, and the Stage 3 final RFP has not come out yet, okay? But my understanding is we may also, even though we have an approved PPA, apply for that Stage 3.
Okay. Thank you. No further question.
Thank you, Mr. Yamamoto. Next is Life of the Land. We have Mr. Curtis.
Sorry, Mr. Chair. I have just a couple questions for the witness. One, Mr. Yamamoto asked whether you knew whether there were hoary bats on private property controlled, owned, or by a Hu Honua affiliate. And my question is, do you commonly go on to other people's private property and look for bats?
No.
And no more questions. Thank you.
Okay. Next is Commission Counsel, Mr. Kayatsu.
Good morning, Mr. Chair. I have no questions for this witness. Thank you.
Okay. Moving to the Commission, Commissioner Sunstein.
I have no questions for Mr. Pace, Chair. Thank you.
Thank you. Commissioner Potter.
Thank you, Chair. I have no questions for this witness.
So, Mr. Pace, I have no questions as well. So thank you for your time.
Mr. Chair, I had a couple of redirect for Mr. Pace.
Can you state the purpose?
Yes, I just wanted to clarify his answer, the Q&A between he and Mr. Yamamoto about whether the fossil fuel will be operating at minimum load without Hu Honua. And so I did want to have some clarification. It should take less than 1 minute.
Okay, like the other one, you have up to 5 minutes.
Thank you, Mr. Chair. Mr. Pace, are you still on?
Yes.
So I wanted to just follow up with you. Mr. Yamamoto on cross had asked you that even without Hu Honua, helco would be operating its fossil fuels at minimum load, and that that basically Hu Honua could displace their fossil fuels from running at minimum load. Is it Tahiri's concern that helco will run both their fossil fuels at minimum load and Hu Honua at minimum load, which will lead to the curtailment of Tahiri?
Yes.
Thank you, Mr. Chair. No other direct questions.
Okay, thank you, Mr. Pace. That brings us to the end of our cross-examination. We're going to take a 15-minute recess, then move into the closing arguments. Just as a reminder, each party gets up to 10 minutes, and the order will be Hawaii Electric Light, Consumer Advocate, Hu Honua, Life of the Land, and Tahiri Power. So thank you all. We'll convene at 10:20. Thank you. Going to recess.
No, not better. Turn it back on.
Okay, it's 10:20. Do we have Mr. Stewart?
Yes, Chair, here.
Okay. Ready to begin before I call? Okay. Call the hearing back to order. Now proceed with the closing arguments from each party or participant. As I said, you have up to 10 minutes, and we'll begin with Hawaii Electric Light.
Thank you, Chair, Commissioners, and Commission staff for the opportunity to appear before you in this proceeding. The evidence presented in this hearing clearly demonstrates that Hawaii Electric Light and Hu Honua have met the burden required to demonstrate that the amended and restated PPA should be approved. In this hearing, we've heard a lot of testimony on a number of different issues. However, I submit that many of them are beyond the scope of the issues to be addressed by the Commission. To that end, I think it's important that the Commission focus on what's really before it at this time, and that starts with a review of the rather lengthy history of this docket. As you're aware, the Commission already approved the amended and restated PPA in 2017. In that approval, the Commission found that, quote, the purchase power costs and arrangements in the ANR PPA appeared reasonable, prudent, in the public interest, and consistent with HRS Chapter 269 and HRS Statutory Section 269-27.2C in particular. As the testimony that you've heard in this proceeding has established, the terms of the ANR PPA have not changed since that approval. As you've heard from the testimony of witnesses Dean Nishina, Henry Curtis, and Steve Pace, the only party or participant to appeal that prior approval was Life of the Land. In response to that appeal, Hawaii Supreme Court's decision, known as Helco 1, focused on two issues. One, Life of the Land's participation and right to a clean and healthful environment. And two, the need for a quantitative and qualitative analysis of the GHG emissions associated with the Hu Honua project as required by HRS 269-6. As confirmed by the Hawaii Supreme Court in its next decision in this matter, Helco 2, the mandate from the court was to focus on those issues and not to expand beyond them. The record in this proceeding clearly demonstrates that the burden has been met as to both of those issues. First, it is undisputed that Life of the Land was able to participate and exercise its rights. Second, it is indisputable that there has been a quantitative and qualitative evaluation of the GHG impacts of the project. Further, not only has the required GHG analysis been done, but the overwhelming evidence clearly demonstrates that the addition of the Hu Honua project will reduce greenhouse gas emissions on its own. Further, when factoring in the emissions saved from avoided generation, the GHG reductions are substantial and unprecedented for a project seeking the Commission's approval. This was confirmed in the testimony of the ERM witnesses, Abby Kirchhoffer of Ramble, and even the testimony of consumer advocate witness Michelle Daigle. Specifically, she acknowledged that she did not disagree with the conclusions that the Hu Honua project on its own would remove 30,000 metric tons of CO2. She also testified that she did not disagree with the conclusion that when compared to the avoided scenario, GHG emissions would be reduced by 1.4 million metric tons. Additionally, she testified she didn't dispute the overall methodology used by Ramble and ERM in their respective calculations. So even the CA's purported expert on GHG emissions confirmed the major points of the Ramble and ERM analysis regarding the GHG emissions. We did hear some testimony regarding questions or concerns that the CA had, but nothing that would be sufficient to support a ruling that the project will be bad in terms of GHG emissions. As an example, we heard lengthy testimony regarding the quantification and a measurement of emissions from fertilizer. However, in evaluating how much weight to put on such concerns, I would like to point out that witness Daigle could not even quantify whether her concerns would have a material impact on the overall GHG calculations performed. In determining how much weight to give to such issues, Hawaii Electric Light submits that the merely raising of questions or concerns regarding the substantial and substantive analysis done by the GHG experts in this case, ERM and Ramble, without even determining whether they have a material impact on the overall calculations is simply not a sufficient basis for the Commission to disregard the otherwise unimpeached scientific work. As I discussed earlier, there's been a lot of testimony about issues that are not related to the issues that are before the Commission. Included are such issues as the retirement of facilities versus decreased use of facilities in production simulations. Hawaii Electric Light submits that it is not appropriate to tie approval of this project to any required accelerated plant closures, as there's no connection to that. It would be contrary to best practices, as you heard from witness Lisa Dangelmeyer. Simply put, it's not appropriate to judge the Hu Honua project for things it cannot do. What is important is that the undisputed record establishes what the Hu Honua project can do. The testimony clearly establishes that the project will have substantial benefits, including displacing significant material quantities of fossil fuel. It will also provide numerous benefits to the grid, as was also testified by witness Lisa Dangelmeyer. Those benefits of the project are essentially uncontroverted. In closing, I'd like to return to the mandate from the Hawaii Supreme Court. The Commission has already approved this PPA in 2017. The Hawaii Supreme Court sent the approval back to address the two issues that I've talked about. Those concerns have been addressed in this proceeding. I would urge that the Commission keep that mandate in mind in reviewing the record and not to expand the issues beyond what were directed by the Hawaii Supreme Court. For all of the reasons discussed here today and all of the evidence in the record, Hawaii Electric Light submits the burden for approval has been met, and therefore approval is appropriate. Thank you.
Thank you, Mr. Stewart. Next is the consumer advocate.
Morning, Chair Griffin, Commissioners Potter and Asuncion. At issue is whether the proposed amended and restated power purchase agreement should be approved in light of greenhouse gas emissions. As the Commission may note, even after all of the discovery and filings, there has been extensive testimony and cross-examination, which the consumer advocate believes highlights that there are remaining questions regarding the proposed A&R PPA. Mr. Wenton and Ms. Dangelmeyer each clearly stated that Hawaii Electric Light does not need Hu Honua for meeting load and reliability requirements right now. So, consistent with past Commission guidance, if Hawaii Electric Light is to accept Hu Honua on its system, it should only be at reasonable cost to ratepayers, preferably savings and net benefits to ratepayers. Due to the proposed price of the A&R PPA, there is also a request for preferential rates. Because of Hu Honua's bona fide request for preferential rates, Hu Honua has the sole opportunity to meet the applicant's burden for proving that the requested preferential rate is reasonable. But Hu Honua, instead of trying to give the Commission as much concrete information as possible, like updated agreements and plans, only provides its general assumptions about how different aspects of its operations will go. As explained by Mr. Wenton, and then essentially confirmed by Mr. Jacobs under cross, Hu Honua's dispatch assumptions were unrealistic. Mr. Wenton explained how Hu Honua's plan to run the facility above the level it may be dispatched by Hawaii Electric Light's system operators at any given point could decrease the facility's output reserves, and so could affect its dispatch according to Hawaii Electric Light dispatch criteria. In spite of Mr. Jacobs' best intentions and any legitimate constraints on modeling inputs and assumptions, Hu Honua 701, as it turns out, does not offer useful estimates or results. Hu Honua's analysis of system effects, in terms of both displacing other generation and system cost, is regrettably just noise. It only distracts from the Commission's serious consideration of Hawaii Electric Light's full production simulation analysis and the consumer advocate's assessment thereof. Despite party, participant, and Commission efforts to obtain information earlier and throughout these proceedings, it appears that there are remaining gaps in information to address remaining questions. For one example, while there is appreciation for the intent to use renewable energy to produce hydrogen fuel, the Memorandum of Understanding with H2 Energy, first mentioned in written direct testimony of Hu Honua witness Warren Lee, could affect several different aspects of this application and future operations in ways that should be clarified. Dr. Weaver confirmed how running the facility more to meet the extra load for hydrogen production should increase GHG emissions, at least from combustion, if not also from the increase in other upstream feedstock processes, and possibly could affect GHG sequestration through soil effects as well. However, in discovery, Hu Honua refused to answer legitimate questions about its plans. It's like Hu Honua brought up the venture in direct testimony, just hoping to burnish the image of the facility, but was then shocked that we would want to ask about and consider the full effects and implications of it. If the A&R PPA is approved, thus enabling the third-party sales, any potential revenues from such an arrangement should affect Hu Honua's request for preferential rates to cover the costs of construction and operation plus a fair return. That is, the net costs of the facility will be less. And, as Ms. Deihoff Matsushima testified here, it will likely require amendments to the A&R PPA, which will require further commission approval. For another example of remaining questions, Mr. Lee has offered a new commitment here under cross-examination that Hu Honua is willing to have a financial reserve available to provide assurances related to covering the cost to purchase carbon offsets. However, the details of this reserve are not clear and so would need to be clarified before being seriously considered. Despite efforts to obtain project-specific information, there are still areas within the GHG analysis that are apparently based on general, non-project specific data. And so there are still legitimate questions about the ability to assess projected and estimated GHG emissions prior to the Commission's decision on this matter, when that would need to be taken into account, and questions about whether relying on non-project specific data is sufficient to provide adequate assurances regarding the determination of GHG emissions and possible hidden costs. There are remaining questions about whether sufficient information to justify preferential rates have been offered to in turn justifies a significant increase in Hawaii Island customer bills that will likely incur. As noted earlier, the proposed facility will add capacity and energy that is not needed for load and reliability right now. But when trying to determine whether there is an opportunity to accelerate retirement of generating units burning fossil fuels, Hawaii Electric Light does not want to commit to unit retirement dates. The consumer advocate acknowledges Hawaii Electric Light's concerns about this, but offers that a plan, triggered once the proposed Hu Honua facility were in operation and fully vetted, would still be a meaningful commitment. The consumer advocate acknowledges that since the docket was reopened, the record has improved as a result of the efforts of the Commission, parties, and participants, and also recognizes the commitments made by Hu Honua to address some of the concerns. The consumer advocate believes, however, that there are still very important areas that need further clarification and/or information so that there is a clear understanding of expectations, commitments, accountability, and recourse. Thank you very much.
Thank you, Mr. Knox. Next is Hu Honua. Mr. Smith, are you speaking on behalf? Okay, thank you.
Good morning, Honorable Chair, Honorable Commissioners. When my colleague Will Yamamoto asked me to do the closing today, it was one of the most awesome and humbling moments of my career. Awesome because I have great respect for the work of the Commission, particularly in assisting the state's goals in achieving clean, renewable energy and moving away from expensive, volatile, and environmentally harmful fossil fuels, goals which remain as important today as ever before. Humbled because I'm practicing next to some of the top energy lawyers and practitioners in the state. But most importantly, because of what's at stake for our client, Hu Honua Bioenergy, LLC. And all of those who have made Hu Honua's mission to replace fossil fuel generation in Hawaii their life's work. You met some of these people during the hearing this week. You met Warren Lee, CEO. You met John Miata, CFO. And you met Kevin Owen, the general manager. But for all those who you did not get to meet, who are behind the scenes of the plant and count on Hu Honua for their livelihoods, these include record keepers, shift operations supervisors, mechanical electrical supervisors, environmental health safety supervisors, chief power plant auxiliary operators, fuel ash handlers, wood testers, mechanics, welders, electricians, and technicians. Finally, on behalf of the Johnson family, I want to express my deep gratitude for the opportunity that has been given to Hu Honua to present at this evidentiary hearing. The family has been involved in this project for nearly a decade because of their belief in importance of the state's RPS goal of 100% renewable energy by 2045 and want to be a partner in that. As demonstrated in this docket, Hu Honua's state-of-the-art bioenergy facility will actually reduce greenhouse gas emissions and be the first bioenergy project in Hawaii to commit to being carbon neutral by 2035, meaning every year Hu Honua will be sequestering more carbon through regrowing trees than are emitted from its facility, and at least 30,000 metric tons on its own carbon negative by the end of the PPA term, resulting in more trees than currently exist. Consequently, the Hu Honua project will reduce more greenhouse gas emissions. At this time, I would like to direct the Commission and the public's attention to HRS Section 269-6B. This is the version of the law that went into effect on June 24th, 2021. Under this law, the Commission shall consider the need to reduce the state's reliance on fossil fuels through energy efficiency and increased renewable energy generation, and shall explicitly consider quantitatively or qualitatively the effect of the state's reliance on fossil fuels on price volatility, export of funds for fuel imports, fuel supply reliability risk, and greenhouse gas emissions. The Commission may determine that short-term costs or direct costs of renewable energy generation that are higher than alternatives relying more heavily on fossil fuels are reasonable, considering the impacts resulting from the use of fossil fuels. Now, Mr. Stewart spoke briefly about the Hawaii Supreme Court's opinions in Helco 1 and Helco 2, which we're all familiar with. And based on those opinions, the only issue for the Commission to consider and decide today in this docket is greenhouse gas emissions. The Commission has already determined that Hu Honua provides benefits with respect to price volatility of oil, export of funds for fuel imports, and fuel supply reliability risk. Given the conflict in the world today, these goals and these benefits are more important than ever before. Hu Honua, with respect to renewable energy generation through greater efficiency, you have heard testimony in this docket that Hu Honua has invested $500 million to converting an existing steam plant running on fossil fuels to a state-of-the-art bioenergy facility running on locally grown Eucalyptus grandis. Eucalyptus crops can be harvested at 5 to 7 years of growth, a very short rotation for a tree crop. The eucalyptus trees to be used by Hu Honua are plantation crops that are now more than 20 years old and long overdue for harvesting. With respect to Hu Honua's life cycle greenhouse gas emissions analysis, Hu Honua has or will account for all life cycle emissions. The evidence presented demonstrates the Hu Honua project will be responsible for an overall reduction of at least 1.44 million metric tons of greenhouse gases from the atmosphere. Hu Honua's sequestration efforts will include regrowing commercial Eucalyptus grandis trees on the Big Island, which grow from the stumps of trees that have been harvested. The roots don't die and decompose, but continue to live and nourish the growth of new trees from the coppice, all the while locking in carbon. Hu Honua's planting agreements that will result in the regrowth of millions of native trees, both on the Big Island and around the world. You heard testimony from Helco's GHG expert, Abigail Kirchhoffer, who confirmed that Ramball treated biodiesel direct emissions as zero. If those emissions were counted, it would reflect an even greater amount of avoided emissions resulting from the project. You heard from David Weaver, who testified that Hu Honua is the only project he is aware of that has made carbon negative commitments without accounting for avoided emissions. And you heard from Braulio Pickman, a UN verifier and international expert on carbon offsets, which he confirmed will be high quality and reliable. Due to its status as a participant in this docket, Life of the Land had the opportunity and could have questioned any of these GHG experts, but chose not to. This satisfies Life of the Land's constitutional right to participate. In addition to avoiding over 1.4 million metric tons of CO2 during the lifetime of the project, Dr. Jacobs calculated that electricity generation from Hu Honua's state-of-the-art bioenergy facility will reduce GHG emissions in the range of $98 million to $132 million. Although I may have referred to the chair as Your Honor throughout the proceeding, we are not in court and this is not an inquisition. Rather, we are engaging in a healthy political discourse regarding an important bioenergy project on the Big Island that has already been approved by the PUC twice. In reliance on these approvals, Hu Honua has expended $500 million and the state-of-the-art bioenergy facility is 99% complete. So instead of criticizing Hu Honua's voluntary and substantial carbon commitments, which it is making at no additional cost to ratepayers, let's work together to make sure Hu Honua succeeds in realizing its potential. Hu Honua's pricing is the same as when the PUC approved the project in 2017. I would say to the consumer advocate, it is neither reasonable nor fair to use an updated built impact statement, which even you admit that you have concerns about, to kill this project. It is also not fair or reasonable to require that Hu Honua have contracts for 30 years of feedstock prior to the approval of its PPA, when the CA has never suggested such a requirement for any other biofuel project. The greenhouse gas concerns that you have raised in this docket have largely been addressed. Hu Honua will be inputting actual data into its calculator and not relying on estimates. Hu Honua's conservative approach to overestimating its emissions is a good thing, because it means Hu Honua will have to grow more trees and sequester more carbon to meet its commitments. The other issues that the consumer advocate has raised regarding the lack of a defined silviculture plan and actual fertilizer use will have no material impact on the net GHG benefits of the project. Although Hu Honua appreciates that the consumer advocate does not oppose the project, we want your support. To the commission, you approved this project in 2017, and the only thing that has changed since then is that Hu Honua has now conducted a comprehensive greenhouse gas emission analysis and is committed to providing extensive greenhouse gas benefits for the state while providing firm renewable energy for the grid in addition to its carbon commitments that we have been discussing. Hu Honua agrees to place $100,000 of seed money into a reserve fund or escrow account in the account annually to cover the payment of any carbon sequestration deficit indicated in the annual reporting, such that the additional funds will cover the deficit and a minimum of $100,000 seed money will remain in the account for the entire term of the PPA. Hu Honua agrees to a condition requiring Hu Honua to provide a minimum of 3 prospective names of independent verifiers to the PUC, allowing all parties to comment, and after the PUC approves which prospective names are qualified, perform the independent 5-year verification. Hu Honua will select the independent verifier from the PUC's approved list. Hu Honua agrees to a condition that within 60 months of a final non-appealable approval order, Hu Honua will provide documentation to the PUC demonstrating that it has secured additional acreage to provide the feedstock for the remaining term of the PPA. Hu Honua agrees to the recommended conditions described in Section 2F of the CA's pre-hearing statement of position. Hu Honua agrees not to receive a preferential rate for any period of energy generation using out-of-state feedstock. Hu Honua agrees to stipulate to ongoing review by the PUC.
Mr. Smith, that's 2 minutes.
Can I just 30 seconds to finish?
Please close. Please close.
Okay. We cannot afford to turn our backs on this project and all those who have made Hu Honua their life's work. We know we are not perfect, but where we fall short, we are committed to improving and doing better. We have learned a tremendous amount over our time with Hu Honua and believe that the project we are presenting to you today is very different from what was originally proposed. We've adjusted and modified what the plant will be doing and the conditions under which it will be operating because we've listened and learned from community feedback, concerns, and priorities. Hu Honua strongly believes that the result is a stronger, better, and more inclusive PPA that addresses those items. We humbly ask the Commission to consider what we are putting forward, knowing that our goal is to be a responsive and committed long-term partner. So let's look to Hawaii's clean energy future, and to borrow another phrase from Mr. Curtis, focus on additionality and not subtractionality. Thank you for the extra time.
Thank you, Mr. Smith. Next, Mr. Curtis, Life of the Land.
Aloha Kako. Life of Land's board has designated Kat Brady as Vice President for Social Justice. In that role, she has provided valuable analysis of energy projects. Kat Brady will give our closing statement.
Aloha, Kakahiaka. Good morning. Life of the Land would like to thank and mahalo the PUC chair and commissioners, their incredible staff, and their attorney, Mr. Kaetsu, the consumer advocate, their staff, and their attorney, Mr. Knox, Helco and their attorney, Mr. Stewart, Hu Honua and their attorneys, Mr. Yamamoto, Mr. Smith, and Mr. Voss, Tahiri Power and their attorneys, Ms. Wong, as well as all the witnesses for being present during this evidentiary hearing. Life of the Land's 14-year journey on this project has been educational and has raised some interesting questions for our very unique islands in the middle of the Pacific and for the values that we hold dear. Hawaii is not Kansas. Hawaiian culture has influenced how we communicate with each other respectfully. These values are kindness, unity, harmony, humility, and patience, and they are enshrined in HRS 5-7.5, our Aloha Spirit Law. We value community and family, and the unspoken rule is that we must be open and honest with each other. This has been the main issue of contention with the community that we've had with Hu Honua, an entity from somewhere else who use their money and to buy what and who they want. Sadly, in this process, communities get run over. Promises are not facts. Slick polls that cherry pick the definition of community do not reflect the values of our people, many who live lifestyles that are absolutely dependent upon a clean and healthy environment where they fish and hunt to feed their families and communities. As the Kanaka Maoli, the Hawaiians say, the land is the chief, man is its servant. Hawaiians both revere their land and respect the need to take care of it. We understand that these values may be foreign to people and entities from somewhere else. That is why proactively engaging the community early on in any process is crucial. Hawaii's motto is Ua mau ke ea o ka aina I ka pono. The life of the land is perpetuated in righteousness. Mahalo.
Thank you, Ms. Brady. Okay, Tahiri Power is the final participant for the closing argument. Ms. Wong? I think you're muted, Ms. Wong. Or at least your microphone's not working.
I was.
Ah,
No, I
there
was
we go.
muted. Okay, let me start again. Good morning, Chair Griffin, commissioners. Thank you for this opportunity to represent Tahiri Power. As a long supporter of clean renewable energy in Hawaii, Tahiri owns and operates the Pakini Nui wind farms located near South Point on Hawaii Island. Tahiri has been providing helco with clean renewable energy for the past 15 years. Tahiri can provide helco with up to 492 megawatt hours of clean energy every day and historically provides helco with nearly 10% of its energy needs. Unfortunately, there are times in which helco curtails Tahiri because it dispatches its own fossil fuel generators and is contractually obligated to take energy from its must-take generators. This is despite the fact that many times Tahiri can provide helco with cleaner and less expensive energy. This proposed ANR PPA contains a 10 megawatt minimum must-run provision for the Hu Honua facility. This means that even if there are cleaner and less expensive renewable generators that can be dispatched, helco is contractually obligated to take 10 megawatts from the Hu Honua facility. This fact has been confirmed by the helco witnesses. This curtailment issue is further amplified if helco does not cycle off its existing fossil fuel units, but elects to keep them online and running. Both the helco and consumer advocates witnesses have testified that there is no current need for Hu Honua. Yet helco and Hu Honua continue to push for the approval of the ANR PPA. A helco witness has testified that this will result in higher monthly bills for its ratepayers to the tune of $10.97 increase per month for an average residential customer. Indeed, the addition of Hu Honua will increase helco's revenue requirements by $285,746,325 over the 30-year term. Let me repeat that. $285,746,325. Despite the significant increase, helco has made no efforts to work with Hu Honua to reduce its price. This, even though Hu Honua has admitted that it is willing to sell excess electrical generation to a third party at a much lower price. Besides the potential for curtailment of other renewables and higher bills to ratepayers, Tahiri shares the concern of the consumer advocate and the life of the land regarding the validity of helco Hu Honua's GHG analysis and the negative impact to the environment and public health that will result from the Hu Honua project coming online. While helco witnesses has testified that Hu Honua would displace renewable energy, Tahiri has concerns this curtailment was not included in the Rambo GHG analysis. During this proceeding, Hu Honua has made many promises regarding carbon neutrality, but have made no firm financial commitment to guarantee that their promises are kept. Unfortunately, Hu Honua has a history of not being able to perform or otherwise be relied upon as a provider of renewable firm electrical generation on Hawaii Island. We need look no further than the original PPA, in which helco had to terminate the contract because of Hu Honua's failure to meet its contractual milestones. The terms and conditions of the ANR PPA are not prudent or in the public interest, considering its hidden and long-term consequences. It cannot be emphasized enough that the ANR PPA has a 30-year term. Thus, if the ANR PPA is approved, the helco ratepayers and the residents of Hawaii will have to live with the high cost and negative environmental consequences of running Hu Honua until at least 2052. These high costs and environmental consequences of approving the ANR PPA will affect the legacy that we leave for our children. The question is, do you want to leave our children with the opportunity to be 100% renewable and live in a clean and healthy environment, or do we want to burden them with a biomass plant that will significantly raise the cost of electricity even higher in Hawaii, destroy our forests when we most need them to help alleviate the efforts of GHGs, pollute our environment, and that will create an inflexible barrier for other cleaner forms of renewable energy? Hu Honua's operational inflexibility will lead to the curtailment of cleaner renewable resources, such as Tahiri, and will hinder the integration of new renewable resources on the helco system. Simply put, unless helco is willing to cycle off its fossil fuel units to accommodate the Hu Honua's minimum dispatch requirement, adding Hu Honua's additional must-run generation makes it impossible to ensure that other less costly and cleaner renewable generation will not be displaced by the Hu Honua facility. This fact alone should be enough to reject the approval of the ANR PPA. However, Tahiri believes that every project should have a chance to be fully vetted against competing projects. Therefore, Tahiri would respectfully recommend that the Commission deny helco's application for the approval of the ANR PPA with Hu Honua, and instead recommend Hu Honua submit their project to the Phase 3 RFP. Helco has admitted there is no reason for Hu Honua not to participate in the Phase 3 RFP. Alternatively, if the Commission is inclined to approve the ANR PPA, it should approve it with conditions. The first condition should be that helco does not curtail existing renewable generations, such as Tahiri, to take energy from Hu Honua. The second condition should be that helco and Hu Honua negotiate a more just and reasonable price for its energy and capacity. That will be more in line with the current energy market on Hawaii Island and more palatable for helco ratepayers. Thank you again for this opportunity.
Thank you, Ms. Wong. Thank you all for your closing statements. This brings us to the end of the evidentiary hearing. And so just short discussion instructions on the post-hearing briefing. Pursuant to pre-hearing conference order number 38188, the remaining procedural step in this proceeding is post-hearing briefing, which shall be due 3 weeks after the hearing recording is made available to the parties and participants. The commission shall notify the parties and participants in writing, and that's by letter, when the hearing recording is available and how to access it, which shall begin the 3-week post-hearing briefing period. With that, we're going to move toward adjournment. First, I want to ask if there are any other outstanding matters here. With that, I want to thank you all for your participation. We'll bring the hearing to a conclusion and adjournment. Please all have a good day. Thank you for your time.
Thank you, everybody.
Thank you.
Thank you.